It's been a little over 2 weeks since the Magais came to court to essentially argue out their case against the Achimota School and the Attorney General, amongst others, over the denial of their son, Tyron Magai, admission into the Achimota School. Now, back then, the court essentially allowed the lawyers for Achimota School to go back and submit their written submissions, amongst others. And today, the day to which the case was adjourned, the parties are, in court, basically arguing out their cases. The judge is supposed to hear objections raised by the Attorney General, represented by the Attorney General himself, Godfrey Dummy, with regards to the fact that they feel that there is an issue of capacity as to whether or not the applicant has the capacity to actually file this particular case. Now, after about 2.5 hours in that court, the Human Rights Court, the case has been adjourned to May 31st, when judgment will be given. We will be speaking to the father of Tyron Magai as well as Tyron Magai himself to get their response to the announcement of a judgment date.
Well, I think the first respondent, or the lawyers of the first respondent, were trying to foolish our case, that we were even not in the position to bring them to court, But as things went, in a way, I think it is good. We're seeing good signs, that it's in a way in our favor. It goes in a way in our favor, Yeah, man.
Now, you've heard that the 31st of May, end of this month, which is about 2 weeks away, will be the day when judgment will be delivered. What did you make of the fact that finally, after about 2 months, a date has been set for judgment to be declared?
Well, I'm happy about that, and we're looking so that everybody will be free to go do what they have to do, because we have to go do our job, and he too has to start his education. And 2 months is really a long time, because other kids are studying in the school now, so he will have to try to recover all what has slipped by. So I'm happy it's finally going to have an end, to all this struggle up and down.
As the student in question, almost 2 months away from school, and possibly on May 31st, the judgment might go in your favor or not. What are you feeling, and what are you, hoping for?
Okay, I'm a bit excited. There's going to be judgment on the 31st, at least, so that I know we are making progress. And staying home is the part where I'm not very much happy, because it's 2 months. First of all, I've missed the chance of making friends, new friends. By the time I go, I'll be the only stranger over there and stuff like that. So those are the parts I'm missing, and their very first day in SHS, all those, I've missed it already. So we just move forward and make sure that when we get there, we recover, and then we just try to make everything good.
So now the case has been adjourned to May 31. That is the case involving Tyron Magai versus the Achimota School. And my colleague Ni Amama spent close to 2.5 hours in court listening to or following proceedings. Now he joins me to give me his perspective on what essentially transpired today with regards to the key points.
Indeed, the major issue in court today was the issue about capacity of Mr. Tyron Magai to bring the suit before the court, and this was largely argued by the Attorney General himself, Godfrey Dummy. Now, he said that Tyron Magai had failed to file the admission forms given him and also submit same to the school. Therefore, he is not actually a student of the school. Therefore, he doesn't have any power to bring such a case before the court. However, Mr. Magai's lawyer, James Gaunga Nkrumah, also argued that indeed the boy was a student of the school. He, as part of the exhibits that he is presenting before the court, is this admission form that has been filled by Tyron Magai. However, the lawyer argues that it was at the point of submitting this admission form to the school that Tyron was told that you cannot come here until you cut your hair. So in his view, the boy is actually a student of the school. So this was the main back and forth that happened in listening to the preliminary matters in the court. And then came the actual merits of the case, where the lawyers for the Achimota School and the Attorney General argued as to why the case should not be given the attention it needs. And they argued that there was no course of action because, in their view, none of the rules or none of the rights of Tyrone Magai had been violated when it comes to his education, when it comes to his religion. His rights have not been violated. And they also mentioned how making special provisions for him was going to put him above the more than 4,000 other students of the Achimota School who are also coming from various religious backgrounds, and they would also want to practice their religious beliefs and manifestations, and they believe that that was not going to be right in their eyes.
All right, there you have it. My colleague Ni Amama, who has been following this case since its inception. Now, after the judgment day for the case involving Tyrone Magai and the Achimota School, the case for Heniba and Krabia was called. Now, during proceedings, it was realized that a key aspect of the case, which is the filing of the consent letter, was not done in the proper manner. So the judge essentially gave lawyers for Heniba and Krabia some time to go and do the needful, which is file the consent letter, which will allow the father of Heniba and Krabia, that is Mervyn Palmer, to essentially lead him in this particular case. So some recess was given, about 30 minutes or so, after which the case was supposed to continue. But after that 30 minutes, when the judge sat to continue with the case, it was realized that the lawyer for Heniba and Krabia had not completed the filing process for the consent letter. So the judge in this case had to adjourn this particular case to May 17th, that is 11:30 a.m. for the case to be heard. Following the adjournment, let us hear from lawyer of Heniba and Krabia, Wayo Ganamanti, on what transpired today.
I mean, what happened was in respect of a consent that the next friend of the child must provide. No, when a person is not up to 18 years, he or she cannot sue. Must be sued by a representation. That's in law we call the next friend or the guardian ad litem. And so the rules is that you have to indicate that that consent has been given, and the lawyer must certify that. In fact, that has been done. We did that, but we filed it in the registry of the court by getting the registrar of the court to endorse it because it's a written consent, and same was supposed to be placed on the judge's docket. So, and we have a copy of that. We just came to court only to find out that the one that was supposed to be placed on the judge's docket is not there. Apparently, the respondent opposed and said that we needed to file that document. Yes, I mean, when it comes to some of these processes, I mean, if you have to file, it's all about going through the judicial service payment system, because the filing is more about the payment system, where you make payments and then a receipt is issued. That is how the system works. And so the one that we filed at the registry by getting the registrar to endorse it and for it to be placed on the docket, because it's just a written consent. The judge is of the view and supports those who oppose it that it has to be filed. And the judge was clear that you need to file and pay for it. So the whole argument is that you need to file and pay for it. Okay. Because the essence of that document has been met. The content is that there should be a consent by the father that my child is not 18 years, so I'm suing on his behalf. So that is not in dispute. When I indicated and showed a copy of what we have, and it was very good, we had a photocopy of what we have filed. In fact, we filed that even before we filed the process itself. So it is the judge's copy that is not on the judge's file, and that became a consent. And also, because we didn't file it by paying for it as the filing of other documents and serve it on the AG and then the Achimota Board of Governors, it becomes a point of objection, and the court upheld the objection. So we've been given leave to file it through the system by paying. And so the one that we filed at the registry by getting the registrar to endorse it as received it will not pass.
So now the judgment date for the other case has been determined as Monday the 31st of May, 2 weeks from now. Would yours also, are you expecting a similar date with regards to Oheniba and Krabia?
Oh, definitely.
I mean, it could go in your favor or not in your favor. If it doesn't, what would be the next step?
That is what I want to use your medium to express. I'm not speaking in respect of the outcome of the matter, but as a lawyer in the matter, I must be clear with my asnas. We are very much sure that the right of Oheniba Krabia will be upheld by the court. No doubt about that. We know the process we have filed before the court. We know our submissions. The Constitution, the Children's Act is clear. However, the party that is opposing is also saying that there is a form of limitation I can put across. We have challenged that limitation. We have put across the laws and the requirements upon them in respect of the kind of limitation they will put across. So as for the substantive matter, as counsel in the matter, nobody goes to war and say I'm going to lose the war. So we are very much conscious that it is about the substantive matter. The substantive matter is that we are before the Human Rights Court in respect of violations of certain human rights. We are saying those rights have been breached, they've been violated, and the court must hold same. We are very much conscious that at the end of the day, the judge will see our reasoning. The judge will see the substance of the law we have put before the court, and the judge will rule same. We know definitely that it will definitely go in our favor. So for the substantive matter, we want citizens to understand that we are before a court of law, but whatever we have put before the court is against the limitation the state want to place. Because in all this matter, we are simply saying there are some rights to be upheld. And the state is saying that, yes, you have some certain rights, but we can limit it. Now we have put before the court the instances of the limitation, the times they can limit. And this one is not one of those times they can limit a child's rights to education. It's not. So we are very much conscious of what we have put before the court.
So you had the lawyer for the Oheniba in Krabia, who is also suing Achimota over failure to admit him because of his hair. Now he is confident that after a date for judgment is set, the court will rule in their favor in a substantive case. But before that is done, their case has been adjourned to 17th of May, which is Monday, for them to file some processes which they failed to at the beginning of this particular case. You're still watching the Citi newsroom.